Good afternoon, and welcome to the Employer Link webinar series presented by McAfee Taft. My name is Brad Neese, Managing Editor of Employer Link. Today our focus is on the Americans with Disabilities Act, and specifically the interactive process. When the Equal Employment Opportunity Commission released its latest ADA regulations, the agency made it clear that employers should be less concerned with determining which employee impairments qualify as a disability, and instead focus their efforts on trying to provide reasonable accommodations so that employees can continue performing their essential job functions. So today our presenters will discuss the EEOC's shift in position, the new compliance standard, and how employers can effectively engage in interactive discussions with disabled or impaired employees. Our presenters today are McAfee and Taft employment lawyers Courtney Brew and Charlie Plumb. Both represent employers in all phases of labor and employment law, including litigation in state and federal courts, in arbitration proceedings, and before regulatory and administrative agencies. Much of their time is devoted to counseling employers on compliance with a broad range of state and federal employment laws and regulations, as well as educating management on best practices for avoiding disputes arising from the employer-employee relationship. Both are also frequent speakers and authors on workplace issues. So with those introductions, I now turn it over to you, Charlie.
Thanks, Brad. Afternoon, Courtney.
Hello.
Whether and how to accommodate disabled employees is one of the most common questions we receive from employers. And Brad is exactly right. Some recent changes in the laws and the approach the EEOC and some courts are taking when it comes to accommodation really has made the last few months a game changer. And now we're seeing a real focus on and an emphasis on individualized treatment of accommodation questions. So today, Courtney and I wanted to really take a nuts and bolts approach on when and how to handle disability and accommodation challenges at your workplace. And we're going to do that by first discussing what employers' obligations to accommodate there are out there. We're going to talk about types of accommodations you should be considering or may consider. We'll discuss what triggers an employer's obligation to discuss or consider accommodation. Next, we'll talk about what exactly is the interactive process, and finish with a review of best practices, those kind of real-world strategies that will be helpful, hopefully, for you on a day-to-day basis when you're faced with accommodation questions. Afterwards, I'll have an in-depth analysis of the Ohio State University's national championship season for those of you who are willing to stay on the line. But before we get to that, let's start.
Get old.
It never gets old. Never gets old. But before we get to that part, Courtney, why don't you start us out by covering what is an employer's obligation to accommodate, just generally. Give us an overview, if you would.
Well, I mean, in some sense, the Americans with Disabilities Act is a little more simple than some of the other laws that you guys administer. So there's really one clear duty here, and that is you have to reasonably accommodate a disability. Everything you do sort of proceeds from that point. And that's a simple concept. It's something to remind yourself of because these issues can get complicated. If you'll just remember what that duty is as you go forward, I think it's helpful. Let's go through a couple of the basics that you guys probably already know, but maybe haven't thought about in some time. What exactly is a disability? A disability is any type of a physical or mental impairment. It has to be something that substantially limits a major life activity. Substantially limits may mean something to you and may mean something to me, but what we know is it doesn't really mean a whole heck of a lot. It's not supposed to be a really high bar. It's not supposed to be something that's intensely disruptive. It's really just if with a disability it's more difficult or it changes things for you because you have this disability, then that could be substantially limiting. Major life activities, I like to think of them in two different ways. One, verbs. Standing, walking, sitting, bending, any type of action or activity that you might take. That's a major life activity. A new type or a relatively new type of major life activity is also, if a bodily function is impacted by some type of condition, that could also qualify as a major life activity. So the ADA treats disabilities sort of three different ways. One, you have this physical or mental impairment. You're actually suffering from it right now. It's also good enough if you had one in the past. You could have dealt with one of these issues in the past and still be entitled to an accommodation. The third one's kind of difficult to wrap your mind around because it really is, I never had one, but you thought I did, and you treated me differently. So we'll talk a lot today about making sure you don't fall into that third category by what you do or what you say. That's really something that you can honestly protect yourself from in a lot of ways. So we'll spend some time talking about that too. You guys probably already know, but the Americans with Disabilities Act was amended back in 2008. And there had been a couple of cases decided by the Supreme Court up to that time. They had really kind of undercut some of the protections of the Act. So Congress came back in and said, you know what, things got off track. We're now at a place that we didn't anticipate being. And so they really shored it up. And they made it very clear what they expected, and they made it very clear what we were all supposed to do. And so the focus has kind of shifted in a couple of different ways. We'll hit on them as we go today. But if this is something that you've dealt with for a long time, you need to focus differently now than maybe you did 5-10 years ago. So if you're in a real rut of a practice, it's time to sort of reevaluate what your practices are. One thing to keep in mind, the statute is actually written in terms of persons. It's not written in terms of employees or just individuals. So this applies to applicants or employees. So it applies at any stage of employment. You could find yourself having this interactive process during an interview, or during a second interview, or a third interview. And another thing to keep in mind is this is a real hot topic for the EEOC. They're all over it. They have their new strategic plan out, and this is something that they address specifically. Yeah, Charlie.
You know, one thing that sometimes slips between the cracks, it's easy, or easier, I should say, to address physical disabilities. More and more, I think employers are facing mental, emotional, or psychological disabilities, which are sometimes harder to spot. They may be more embarrassing or uncomfortable to address, but the accommodation obligation is not just for the injured back or the chemotherapy I'm going through. It's also if I'm suffering from clinical depression. And keep in mind, when we're talking about accommodation, that applies to those mental or emotional or psychological conditions as much as physical.
Just the same, just as much, same obligation. So we know from the EEOC that they're interested not in whether or not someone has a disability. They're interested in employers, what did you do? Did you sit down and have this interactive process? So both because of the changes in the law and the change in what we know the focus is from the EEOC, you almost take a short-sighted approach towards the disability question, and you need to move in and plant both feet in this interactive process and decide what to do going forward. Now, I don't love talking about the exceptions sort of to providing an accommodation, but there are two, and you should be aware of them because they do come up from time to time. One is if providing the accommodation would put you in the situation of an undue hardship, then you're not required to provide it. That needs to be an individualized inquiry too. That's not something that you just need to make off the cuff. You need to spend some time really thinking through what is it that's being requested, and I think I can't provide it, but can I verbalize that? Why is it that I think we are going to have an undue hardship to provide it? You need to consider things like how much does it cost? What size employer are we talking about? Some things are easy for big employers to do and not easy for small employers to do. Yeah.
I'll give you a recent example, I think, Courtney, that puts a real fine point on it. It involved a nursing home hairdresser. Part of her duties were wheeling some of the residents that were non-ambulatory to the salon in the assisted living location. And because of that hairdresser's inability to push people in wheelchairs, she lost her job, and she filed an ADA claim. And to your point, when the undue hardship is a defense, but it's the employer's burden to prove that, and that can be tough sometimes. In that case I just described, what's happened is a jury is going to decide whether pushing wheelchair is really an essential function, a core job duty or not, and that may go for the employer or it may not.
And that nursing home is in a much better position if it can prove during the course of this lawsuit that, we got everybody involved, that was important to the decision. We sat down and talked about what we could accommodate and what we couldn't. And if you have that additional process in place, you're in a much better spot going forward. So take some time and really think things through and document your discussions with people, document the alternatives that you've considered. All of that can really come in and help you down the road. There's a second type of exception to providing an accommodation, and that is providing the accommodation would pose a direct threat either to the employee or to other people in your workforce. A direct threat is a significant risk of substantial harm, and you see this a lot in the manufacturing context. So you have somebody that's working a heavy industry position, they have some type of a mental or physical impairment, and it would be really dangerous to have that person out there on the line working with this machinery in light of the issues that they're dealing with. This is a pretty common, I don't know about you, Charlie, but I get questions on this from time to time. And it's a very high burden. You have to be careful when you're thinking in these terms, but there are situations where it's just too dangerous. You can't have somebody operating under these conditions or with this type of equipment because of what they're dealing with.
It's almost a level of being in a situation of whether you can demonstrate it is truly a safety-sensitive position, whether it's maybe a vehicle operation, heavy equipment operation, pipeline, those sorts of things.
Right. If you're not dealing with one of those situations, you're going to have a really tough battle in front of you trying to prove a direct threat.
So let's talk now about what sort of types of accommodations come up in the real world. And for my own purposes, I think of 6 categories of types of accommodation. And these aren't carved in stone, but they help me think about what I should be considering in the context of accommodating or potentially accommodating disability. And the first type of accommodation that may come into play is some sort of physical change to the work environment. And that could be exterior or interior work environment, but we're talking about things like improving accessibility, maybe that's ramps, parking, door width, those sorts of things, or perhaps acquiring or modifying equipment or devices that are used in the workplace, things that assist people with hearing difficulties or perhaps eyesight issues to work. The second category of accommodations are what I'll call job structuring, and those are situations in which perhaps a disabled employee is unable to perform certain functions associated with their position. Well, is shifting job functions or modifying the actual duties, those that the disabled employee cannot perform, is that an option in terms of accommodation? Now, we're not required to reassign or modify the real core essential job duties and functions, but those that are less than core or less than essential, marginal versus essential, maybe job restructuring, shifting of assignments can be considered.
And one thing there, Charlie, before you go forward, that can be a not popular thing in the workplace. If you have one person whose job needs to be restructured and they need to shift some duties onto other people, that could be not popular.
Right.
But that's not a reason to not do it.
Yeah, and there's a lot of case decisions out there that says, look, morale or unpopularity of decisions in the context of accommodation, that's not a reason or defense for not accommodating, because the reality is a lot, as you say, Courtney, exactly. So when you're talking about shifting job duties or responsibilities, that's often unpopular, and if you could use that as a reason not to accommodate, accommodation wouldn't occur very often. Category 3 on accommodations, modified work schedules, someone that perhaps suffers from a particular medical or health condition that starting perhaps later and working later or accommodating through some breaks in the workday, that could be a form of accommodation. There's a lot of case law that says, if it's too unpredictable, that is a modified work schedule, we don't know when or whether someone's going to come in, that might be treated as unreasonable. Category 4 of accommodations would be giving an employee a leave of absence, an unpaid leave of absence, and I'm talking about that in terms of considering it as a form of accommodation, something beyond what is already provided to employees under the FMLA, or perhaps it's an employee who is not yet eligible for FMLA. One thing to be careful about, again, we have indefinite in duration when it comes to leaves of absence. They may be treated as unreasonable, and employers may not be required to consider that. But I don't know if you've run into this, Courtney, but sometimes we'll find employers who have sort of what I'll call a blanket leave policy where there are no exceptions, those are often subject to challenge. Have you run into those?
I see those all the time. I do. And it's a difficult thing if you've had somebody that's been out for, say, 12 weeks of unpaid leave to then say, well, we can't accommodate one more week. That's kind of setting yourself up to be in a tough spot to defend. Yeah,
and a couple of recent examples to give a little bit of flavor. Super Value grocery store had a policy that applied that if you were returning from leave, you could only return to your job unless you could prove you didn't have a need for any sort of accommodation. And that resulted in a consent decree of $3.2 million against the employer. Princeton Healthcare System had a policy much like Courtney just described. They had a flat ban on anything exceeding 12 weeks, the 12 weeks that were already afforded by FMLA, and the EEOC said, you know what, you've got to address those on a case-by-case basis. If it's just another week, like Courtney pointed out, you ought to consider that as an option, and that was also the source of litigation by the EEOC. So that's a real issue, and I think it reinforces the idea that when we're talking about any sort of accommodation, you've got to address it on a case-by-case basis. It's going to be a function of the particular medical condition at issue. It's going to be a function of the job at issue, and it has to be decided on a case-by-case basis. Category 5, in terms of accommodations, is a possibility of reassigning a disabled employee to a vacant position. Now, a vacancy must exist. You're not required as an employer to create a vacancy. You're not required to displace employees in existing positions. You're not required to move people around to create an opening. The vacancy must exist, and the disabled employee must be qualified. They must have the skills, the experience, and the education, just like anybody else for that position. If you're looking at reassignment to a vacant position as a type of accommodation, look for first an equivalent position. Try and make it as equivalent in terms of duties and compensation as possible. But if you don't have an equivalent position at the time that's vacant, you can always consider moving the employee to a vacant, lower-paying job. And do you ever get questions about what do I do if I reassign in terms of accommodation a lower-paid job?
I do. I think people are scared to do it, and with minimal exception, I mean, the response has been positive from the employees. They realize that they need a reduced schedule. They think it's fair to pay less for a reduced schedule, and honestly, they're just grateful to have somebody that's working with them so that they can get through whatever it is they're dealing with. So don't be afraid to approach that possibility.
That's exactly right. Now, I think here's a kind of a counterintuitive issue when it comes to reassigning to a vacant position. Let's say you've got a vacant position, and I'm a disabled individual, but I'm qualified for that job, and Courtney's a non-disabled individual who's also vying for that same vacancy. Guess what? I get preference over Courtney because I'm disabled. It's almost it's akin a little bit to affirmative action,
right?
But that's the truth. If you've got a disabled and a non-disabled individual vying for the same vacant position, and it's in the context of an accommodation consideration, that disabled individual gets the nod. I get the nod over Courtney. In that particular case, there are a couple of exceptions. If you are covered by a collective bargaining agreement that has a seniority provision, you can give Courtney that job if she's got seniority over me. The same is true if you have an established seniority system that you consistently and routinely enforce. Again, to use our example, if Courtney was not disabled but beat me out in an established seniority system, I don't get that preference typically. The last category, category 6 of accommodations we deal with are the question of whether an individual who's suffering from a health or medical condition could perhaps be accommodated by telecommuting or permitting them to work at home. And really the crux of those decisions is, again, a case-by-case analysis of whether it is essential that I be physically present in my job. And with office technology and business technology advancing so rapidly, we're seeing more and more issues or situations in which telecommuting or working from home, in part at least, is very real and very reasonable.
And one thing to consider here, reevaluate your jobs and your job descriptions. Do you have people that need to be physically present in the workplace? Does their job description say that? Because what we're seeing are a lot of cases that apply to us here in Oklahoma where when you had a good job description that said, this person needs to be here every day because they coordinate with a lot of different people and that requires, face time and, not scheduled time. Just they need to be here because anything can come up. When we see job descriptions like that, they've been very influential on courts to say, yep, being present in the workplace every day is an essential function, then you don't have to accommodate the absence.
That's a great message. Periodic review and updating of your job descriptions really help you go through this accommodation process or defend or use to defend your decisions and your actions if someone challenges you on what you did. And one thing before we move on to what triggers the interactive process, remember this. Sometimes you may be in a situation which you're really stumped. You're not sure if a particular accommodation is reasonable. You don't know if it's practicable. You don't know if it's going to be a train wreck. And there is absolutely nothing wrong with saying, Courtney, we're going to try this for a while. We're going to try you in this other position, or we're going to try this modified work schedule. We're not sure it's practicable. We're not sure if we can pull this off, but let's give it a try for a week or 2 weeks, and then let's regroup and see if that works. I think that's a really good strategy in any sort of accommodation if it's a close call.
I think that's a great idea, and you tend not to think that way. But if you do set someone up in a trial type of accommodation, you need to follow up with that person and make sure that it's working. And that person should be instructed to tell you, hey, it's working or it's not working. Can we try something else? Another thing, I'm looking at these slides. These are examples.
You're actually looking at these slides?
These are examples of accommodations. You can come up with pretty much anything under the sun and give it a whirl. You get to be as creative as you want, and we'll talk about this more, but your employee can be creative. So these are some really common examples, but there's a lot of other ways out there that you can approach these issues.
Yeah, one last thing on that give it a whirl approach. You want to make sure you communicate that to the employee. They need to understand that you are going to be revisiting the issue. And I'd put that in an email or I'd put that in a memo and I'd talk to them and say, we're not sure this is going to work. Let's see. And because you don't want to be in a situation where you go to somebody 2 weeks later and say, this is not working for us. And you get this look from them saying, well, you didn't tell me this was a trial basis. Make sure we're communicating that well.
And remember, sometimes there's multiple accommodations that can address a particular issue. You as the employer have the final say. So if there's a couple of different ways out there that you can combat an issue and you really want one and the employee really wants one, at the end of the day, it is the employer's decision. Something else to keep in mind. Yeah,
and that's a great point. You have the veto power. You don't have to agree with my request of, I like your request, but I like mine better. It's employer's selection. That's right.
Charlie's going to talk a little bit about what you do in one of these interactive discussions, but I'm going to talk about when do you have to have one? How do you know it's time to have this conversation? This is interesting because you really kind of have to have your eyes and your ears open. It's not just an issue of someone coming to you and saying, I need a reasonable accommodation. You kind of have to be alert and watch what's happening and be a little bit perceptive. There's no special language that an employee has to come to you with. They don't have to walk up to you and say, you know what, I'm struggling with a mental impairment that substantially limits one of my major life activities, and I need a reasonable accommodation. That's just not going to happen. And it doesn't have to happen. They don't have to give you anything in writing. They don't have to go to a particular person and make this request. Any type of notice to you can trigger your obligation to have this discussion. Once you do know, it's your responsibility to initiate that discussion. You can't wait back for something to happen. Yeah.
Here's one thing we hear periodically, and I'm a little bit exaggerating, but not a lot. You know what? We didn't consider Courtney's accommodation really because she did not complete Form Q3 and file it within 3 days. I mean, I just want to emphasize exactly what Courtney's saying. It's going to be on us, and it doesn't have to be in writing or magical language. And that happens. We get a lot of questions like, well, they didn't ask me the right way.
Yeah, I'd be careful there. I mean, especially if you're a really big employer, you're going to have all these processes in place to try to help you administer your obligations. So you may have forms, and you may have designated contact persons, and all that's fine. I mean, Charlie and I aren't saying that those aren't good strategies to help you with your obligations under the Act. But, you know, ADA is not FMLA. We don't have a lot of forms to throw back and forth, and there are boxes that have to be filled out and checked. You know, so if you have one of those processes in place, that's great. But be aware that that doesn't rule the day. That's not something that is contemplated under the Act, and so it's not something that an employee technically has to, you know, adhere to in order to get an accommodation under the Act.
And you're still going to want to encourage your employees to fill out those forms and follow the policies, because it increases the chances that we catch those issues and address them timely. But, you know, medical issues are personal. They're sometimes embarrassing. So we have situations in which employees don't want to fill out those forms. Keep those policies in place. Use your forms, but as Courtney said, keep your eyes and ears open as well.
You know, and Charlie and I hear it all the time. We know you don't love having these conversations, and that's totally understandable. But when do you have to have them? If an employee comes to you and says, I need help, or I'm struggling with an issue, or, you know what, I can't do this aspect of my job as well as I used to be able to do it, it's time to have the discussion. That's notice to you that there's something going on. Now, if someone comes to you and says, you know what, I can't do this part of my job anymore because I need to drop off my kids at a new school that's, you know, this far away from my job. That's not what we're talking about. What we're talking about is there's some type of physical or mental issue that's causing some type of change to how they're able to go about their job duties. What happens a lot of time is you'll get this information in another context. So maybe there is a request for FMLA leave, and you do send out the forms, and you'll get some information back. You can see what that information is. You can rely on that information as a trigger for your interactive discussion. And the same goes if you get information because of a workers' comp injury, or somebody was gone for some period of time and you do a return to duty and they come back and we see some issues that need to be addressed. You don't have to turn a blind eye to information that you get for one reason to consider that information under the ADA. You get to consider all of the information that you get together. Sometimes, and this happens, sometimes you'll get only half of the information that you need, or you'll have maybe the first discussion and you don't get all the information that you want. It's up to you. You have the right to say, I need more information. Or, you know what, that form you brought me from the doctor, I need a little more than that. I need some clarification on that. And, you know, treat this the same way. You guys are probably all familiar with this FMLA paperwork that I now keep talking about, even though that's probably a different webinar. But, you know, what happens when you get the FMLA paperwork back and it's not complete? Well, you get a second chance, and you get a reasonable amount of time to get that information back to your employer. The same should go here when you're trying to get information from someone about a potential disability and they're giving you a doctor's note and you need more information. Give a reasonable amount of time and give a second chance.
You know, in a lot of ways, it's kind of like harassment complaints. A lot of times you may find out about someone's medical condition in a secondhand fashion. Do you run across that?
I do a lot. That kind of goes into this next point, is that sometimes employees will confide in a coworker or a supervisor that they've worked with for forever, you know, that someone that they feel very comfortable telling this information to. Everybody has their work buddies, you know, the people that know them better than other people at work. And a lot of times I get calls that say, you know what, someone just came to me and told me that Sue is having issues doing this, or Sue just got diagnosed with XYZ. What are you supposed to do in that situation? You turn a blind eye to it, or do you act on it? Well, you act on it. You absolutely act on it. You need to now go and talk to Sue and let Sue know that you're there, you want to know what's going on, and you want to talk to her about what we can do as an employer to help her deal with whatever the disability may be.
You know, I'll give you a recent example of a workplace observation I ran into. It was a client that operated heavy equipment, and there were two employees, coworkers that worked together on a lot of the projects, and the supervisor just happened to notice that all of a sudden one employee was performing more than their fair share of the heavy duties, and it was obvious that an arrangement had been made between those two coworkers. Hey, let me do that, and that's not an unusual way to first learn there's a problem. You just see things happening, people avoiding particular tasks, or perhaps other employees pitching in, or just visually having difficulty with portions of their job. That happens a lot, I think.
Yeah, I agree. I mean, you'll see things sometimes. You'll see someone struggling with a job that they've done for years with no issues at all. When you see that, it's time to act on it. I got a call just a couple of weeks ago from somebody that said, I may be jumping the gun, but John has worked for me for more than a decade in a very heavy physical type job. And all of a sudden, John is not as productive as he used to be. His quota is down. And I know John, and John's a hard worker, so I'm convinced that something's wrong with John. And we want John to stay with us. We want him to continue to be employed with us. Can I talk to John and see if something's wrong? That was the phone call. Can I have the interactive process? Absolutely, you can have it. Don't feel nervous or uncomfortable in going ahead and approaching John. And they did, and there was an issue that they could pretty reasonably accommodate, and everything's great now.
I think a great point you're making, Courtney, is the way the law has changed and the way the EEOC is approaching this whole accommodation issue. Like a lot of HR questions, you've got to be the proactive person. You've got to be the actor. You can't be reactive. And in the long run, being proactive, addressing potential medical conditions and potential accommodations is always going to serve the employer best.
Err on the side of having the conversation. I think that's a takeaway. That's a great
point. So we've been using this phrase, the interactive process, and that's the phrase that's used by the EEOC in its regulations on how you're supposed to go about discussing and considering potential accommodations. And think of it as kind of a guide on how you're to have this discussion and how you're to consider potential accommodations. So let's go through the basics. What is the interactive process under these regulations and according to the EEOC and the courts? Well, first, it is a discussion. It's a communication, and it is interactive. What does that mean? It means it's a two-way street. This is not where you are pontificating or lecturing the employee. I mean, it is envisioned that you're going to have a discussion with the employee about their condition, about their job, and you're going to exchange ideas and information, and that's very important. It needs to be flexible and informal. It's not carved in stone. It needs to be tailored to each particular circumstance. It's going to be a function, how it happens and what is said and what is discussed and considered. It's going to be a function of their medical condition and the workplace needs.
I always stress the informal requirement. This is a difficult thing to talk about. You don't really want to have the conversation. I guarantee you your employee doesn't want to have the conversation. Be sensitive to the fact that you're probably dealing with someone who thinks it's a bad thing that that they have a disability, right? They're afraid of what's going to happen. They're afraid of losing a job. So it needs to be a comfortable environment, a familiar environment. Don't make this person go somewhere they never go to have this conversation. I mean, that's just starting off on the wrong foot. Have people in the room that they know that they're comfortable with. If you're fortunate enough to have a multi-member HR staff and you have somebody that is just good at this. I have clients and they have people that are just good at having these conversations. And so whether or not they're in charge of this employee's particular unit, that person is always in the room and involved because they're just good at it.
I'm going to get my mom involved in the next one.
I have my mom involved in all of these.
Well, and your point is an excellent one. When we're talking to an employee about their health condition, it's very private. It may be embarrassing. And guess what? More often than not, I'm going to understate my problems. It's not a situation in which, you're going to have to kind of pull it out of me a little bit. So making them as comfortable and as relaxed as possible is very, very important.
And you know what you're not entitled to? you're not necessarily entitled to a specific diagnosis. You're not there to have like a doctor-patient relationship. You're entitled to know whatever you're dealing with, how is it affecting you? What can you no longer do? You don't need, the 60-letter term that defines the condition. That's not what you're looking for.
Right. Yeah, Courtney's not a doctor, but she plays one
during webinars.
That's right. Okay, so, it's flexible, very important, informal, critical. It is an information gathering process, okay? It is a two-way process where you're talking to someone, and you may be asking medical information to really establish and clarify whether they need an accommodation, and if so, really what that accommodation may look like. And to make this work, both parties, both you, the employer, and the employee, have to participate in good faith. I mean, think of it as this isn't a challenge. I'm not challenging somebody whether they're good enough or capable enough to continue to work with me. I'm in a problem-solving mode with you. And that's, that must be approached in a problem-solving way, not doing the paperwork to get them out the door. More and more, we're running into instances in which employees are a little difficult. They're not participating in good faith. They're not holding up their end of the bargain, if you will, which also puts a premium on doing it in a fashion and in an environment where it's more likely to be successful.
Yeah, Charlie and I were swapping stories a little bit before we got started today about it's gotten very common to have employees that are maybe not fully holding up their end of the deal. So you have to talk to them. They have to talk to you back. Charlie gave me a case right before we started that I was reading where someone sat down to have the interactive discussion with an employee and said, we can't do this accommodation for you, but let's talk about these other accommodations. And the response was, fine, I can tell that I have no choice but to quit, and just walked out. That's not holding up your end of the bargain. You have to participate too.
And, you may have even run into instances, we'll talk in a moment about medical information. You may get stonewalled by your employees for medical information. Courtney, when we get to medical information, I want you to talk about your recent experience. We mentioned that this is a proactive process. That also means don't sit on it. Act expeditiously. Once you have a heads up that you may be dealing with a disability, you may be dealing with an accommodation issue, don't drag your feet. Get the process started. And keep in mind, this is medical information, so make sure we keep it confidential. Now, there's going to be some people that need to know about it, like supervisors. You're going to get them involved to see whether a particular accommodation, in light of the medical information, is reasonable or practicable. So there is going to be some sharing, but keep that sharing of that information on a very, very limited basis.
Something else you might want to think about doing too, when you have one employee that has, let's say, a job restructuring, certain things that they used to have to do, they're not going to have to do anymore. It might be a good idea to have a conversation with that supervisor, because that supervisor is going to get questions about why this person no longer has to do the bad part of the job that the rest of us have to do.
And it's always the bad part.
It's always the bad part.
You never lose the good stuff.
The stuff you like.
Yeah.
Right. So, get that supervisor ready and give that supervisor, almost a script that just says, we've given this person a reasonable accommodation and, it's an issue that I'm not going to address with you. and very quick conversation and move on. But have that supervisor prepared to deal with that. I've actually had a couple of occasions where supervisors may be saying things they shouldn't be saying, giving more information than they should.
Yeah, and do this in a face-to-face basis. This isn't done by emails bouncing back and forth, because it's hard to really pull it off in a kind of interactive, productive, problem-solving manner. There may be follow-up emails, or letters or voicemails, but I think it really needs to be face-to-face. And I like to have two employer representatives present, not to gang up on somebody, but, generally you're going to need the HR person that really is sensitive and experienced with dealing with these issues, but you're also going to need to have the supervisor there who, when you start talking about specific tasks or modifying or eliminating specific tasks, you're going to need somebody in that discussion that says, hey, that will work or that may not work.
It's just like anything else. You get further when you're being respectful to somebody. So, put aside enough time to really devote to this. You you don't want to be halfway through the conversation and say, oh, you know what, staff meeting started, I'll get back to you later. And you don't want to do this over the phone because it seems like, well, I don't have time to sit down and talk to you about this. Again, that's getting off on the wrong foot. So keep that in mind. Give yourself enough time. Show up. Be there. Have other people that are important to the situation show up and be there. And then the employee feels, okay, this is important to everybody. People care about me, and people want to know how I can get back to work.
And when you're having these kinds of discussions, talk about what is at issue. If it's, for example, if I'm having difficulty with my back, I've had surgery to my back, and so lifting is an issue, that's what you need to be focusing on. Not, as Courtney said, not my diagnosis, not what my blood pressure is like, not whether I'm suffering from clinical depression. You're there to talk about accommodating and addressing my lifting. Keep it focused on the medical condition, not the cause, not the diagnosis, but capabilities. And talk about the nature, extent, severity of any impairments and how long are they going to last. Are they going to be ongoing and open-ended, permanent, or is this something that is going to rectify, is going to resolve, and I'm going to regain some of my capabilities? You are entitled to look at or request medical documentation. So let's turn to that issue, because sometimes that gets a little complicated or a little unpleasant, but that is a clear right when you're dealing with accommodation issues. Again, when we're seeking medical documentation or medical information to determine, whether accommodation is really needed, and if so, what it's going to look like, it should only be focusing on the medical condition you're dealing with. And it should focus on and ask, again, for, the nature and extent of that individual's capabilities. That's what we're focusing on the whole time. Provide their doctor or their healthcare provider a description of what the job's essential functions are. If you've got a job description, that's great. I even had an instance a couple of years ago. I thought this was brilliant. It was a heavy manufacturing environment. We had a long-term employee who had suffered a series of back injuries and had surgery, and we were trying to get our arms around whether he could come back in full capacity or was going to require some accommodation. And we had an HR person video the job being performed on their phone, and then we forwarded it to the treating physician. Have you run into things like that?
You told me about that. I thought that was a really good job.
Brilliant idea.
Yeah.
Remember, you're going to want the employee to release the information, provide a release, because we're going to be looking. We want to look at these documents and see what the healthcare providers are saying in terms of their capabilities. And, I like, on my first pass, I like to ask for that kind of information from whoever is treating this physician, because I think, that gives me a stronger hand to make decisions and rely upon things. If someone's going to question what decisions I made in terms of accommodation or what I didn't do, I'm in a better place, aren't I, Courtney, if I'm relying upon the employee's own healthcare provider?
That's right. That's about the best place you can be.
Yeah. Now, sometimes you can't get that information or it's not high quality, and you can then use your own healthcare professional. But I really recommend starting out with your employee's professional.
Going to have a better history. I mean, they're going to be able to give you more complete information.
Absolutely. And you may run into, what do you do in a situation when you get that report from my doctor who's been treating me, and it's one line, he's cleared to return to work? Do you go back to the well and ask for more information? Do you send me to another doctor? What is your advice on those sort of circumstances?
I think there's always no harm in going back to the well at least one more time.
Okay.
And make it very clear and include the employee in that decision. Just say, hey, you know what, we got the note back from your doctor. That's great. It didn't, have a whole lot of information in it. So can you reach out to him and get us some more information, or keep the employee in the loop on that. That way it doesn't look like you're, combating the accommodation process. Just that, all right, well, we need more than that. So let's go back one more time.
Courtney, you talked about this earlier. Maybe we could dig a little bit deeper with you here. You are getting potentially medical information from a variety of sources about your employees. I may be on FMLA leave, as Courtney pointed out, sending a medical certification. I may have an open workers' comp claim, and you're seeing my treatment documents What role do those play, or how do you see those being used in the context of accommodation?
Well, like we talked about briefly, I mean, you can rely on those. You can look at those. You can use that information to determine what type of accommodation you should provide. The thing that still interests me is that a lot of times when I get questions on any of those topics, the question comes in and it's just tunnel vision. It's just an FMLA issue. And we'll talk through the FMLA issue, and then at the end, okay, well, have you had an interactive process? Because clearly this serious health condition is also a disability. The light comes on. It's like, I haven't even thought of that. You're going to have, and a lot of the time, you're going to have multiple processes going on at one point. You're going to be dealing with the FMLA. You're going to be dealing with the ADA right alongside of it. Don't forget your different obligations under each different law, and work those processes in together to help you get as much information as possible and come to the right decision.
Yeah, and it's not, remember, you've got a few balls in the air, but you're entitled to look at some of those other documents and say, wow, I know this is an FMLA document, or wow, this is a workers' comp report, but it's also advising me of some limitations or physical issues that I need to be on point on when it comes to accommodation as well.
And remember, that paperwork can give you notice of other conditions. So maybe you started on your interactive process and you were just talking about a back injury, and then you receive additional information that comes in, there's some type of shoulder injury. Well, you can't just limit your interactive process to the back injury at that point. It may broaden or it may narrow a little bit based on what's going on under those other processes.
Now, documentation of what happened in the interactive process, that becomes very important in two ways, I think. First of all, this interactive process is kind of clunky, and it can be uncomfortable, and it can be embarrassing. So I put a real premium on making sure that you, the employer, and the affected employee are on the same wavelength. And one way you can make sure the employee understands what's happening is what is going to happen when it comes to accommodation is giving them an email, giving them something in writing that summarizes your discussions and what we're going to do or what we're going to try. So I think that's the first context in which documenting the interactive process is important, making sure the employee understands what's happening, why, communicating that. And sometimes you discover in that documentation process the employee has heard or understood something differently. The other reason I think documenting and discussing the interactive process is important is if down the road someone is challenging what you did or what you didn't do, and that may be in the form of an investigation by the EEOC of a disability claim, it may be a lawsuit, it could be in a variety of contexts. That documentation is going to be very important in memorializing and establishing what you did was appropriate, fair, and lawful.
One thing that you have to do, it's not on any of our slides, but you have to do it during the interactive processes. You kind of have to build some trust with this employee, that they can talk to you, they can confide in you, you're going to keep things confidential, you're trying to help them, you guys are on the same page. When you take notes, and it's perfectly fine to take notes during one of these conversations. Anytime you take notes during any type of conversation with an employee, they should be just factual, right? This was said, this was said, this was said. Maybe after the fact, you go in and you embellish those notes with kind of what your thoughts were. But you should have a real set of factual notes. I have a client that after she has these discussions, she takes those very factual notes and she gives a copy. She makes a copy and she gives it back to the employee. And she says, all right, this is what we talked about. I'll visit back with you again in a couple of days. But in the meantime, if you think of anything else or you want to talk about anything else, and I think that goes a long way to making the employee feel like we're on the same page. This is a friendly process. They're trying to help me.
Yeah, that's a great practice. Okay, so what are some tips about documenting the whole interactive process? Well, what you're really trying to do is make sure you're putting together a good record of what was discussed with the employee, what they said to you, what you said to them, and also a record of what you're getting in the way of medical information. And your medical information may come from a number of sources. I mean, some medical information you're getting is from what the employee tells you, or maybe a coworker says they've confided in. And it may also be medical information from third-party healthcare providers. But keeping track of all that is very important. This isn't just a one-meeting situation, right? I mean, it may take a number of discussions. It may be a work in progress. I mean, do you run into instances in which you're having a couple of these meetings with an employee?
I do. I mean, you're going to walk into that meeting and you're going to find out things during that discussion that you didn't know before. And you need more than just however long that discussion takes to think about how to accommodate those. I can tell you a story that I had a client. They thought they knew exactly what the issue was, and they were pretty right. And so even before, and this happens, you guys know it, even before the meeting, they know what types of accommodations are on the table and what types maybe aren't on the table. So they had a discussion with the employee, and I told them, there's really no benefit into giving an accommodation right there on the spot. Take some time, think through things again, see what happens. So she did that, and they had decided what they were going to do, and they were going to buy something. They were going to buy like a piece of furniture, basically, to make things easier for someone. And the employee came in the next day and said, I thought about it overnight, and I have another idea. And it was a very inexpensive idea, and they ended up going with it, and it took there were no issues going forward. And it was something that they hadn't talked about, that nobody had thought about. And just by building in the extra time for people to think a little bit more about it, and on their own, when they're at home and comfortable and not, face-to-face with their boss, people can come up with other ideas that can benefit you too. So take some time.
Yeah, it's like a lot of HR decisions. I think more and more, a lot of the times I'm recommending don't make any decision quick. And that certainly applies to the accommodation consideration.
That's right.
One thing I also think is important, this interactive process includes discussing potential accommodations that aren't workable, aren't practicable, do impose an undue hardship. And they may be ones you suggest and reject, or they may be suggested by the employee, but that you're just not going to be able to do it. In that documentation, you want to keep track of all these ideas and including what discussion or what conclusions were reached, why certain ones of these options were not doable. Make sure that's in there. And we've already talked about the fact that, keep in mind, I think a really good tool is this idea of trying an accommodation on a trial basis or short term. That's always, if you're struggling and you're not sure if it's going to work, that's a great escape valve. And it also, if it doesn't work, it is the absolute epitome of trying in good faith to solve a problem, I think. So let's go, Courtney, through some best practices. Give us your thoughts on what we really should be honing in on a day-to-day basis.
Well, and they all fall under one umbrella, almost. The best practice is to always take time and consider the individual circumstances that are present. Go through, really consider the job, really consider the accommodation. The temptation is still there for people to sort of dig their heels in and say, I'm not sure this qualifies as a disability. And that really can't be your gut reaction anymore. You need to err on the side of the caution that it is a disability. With the changes in the law, there's just a lot more conditions that the EEOC wants you to just assume it's qualifying as a disability and move on and discuss accommodations. Remember at the very beginning of the webinar, we talked about substantially limits and what that means. We know that's a low threshold. We know that this doesn't have to be something that basically leaves you homebound before you can get an accommodation. So don't look for somebody who, can't do anything without an accommodation. It doesn't take a whole lot for somebody to have a major life activity impacted, and impacted in any way, shape, or form. So don't dig your heels in there either. We've kind of hit on this a couple times today, the importance of training your managers and your supervisors, training them to spot performance issues that may need to lead to an interactive process. A lot of times these guys are going to be involved in the interactive process itself, and it would be really helpful, and you would get a lot of benefit out of giving them some training on do's and don'ts while they're in the room during the interactive process. If you have the grouchy face supervisor, let's try to calm the grouchy face before we have the interactive process. They can really help you. They're out there on the front lines. They're the guys that are going to know first. So if they know what to look for and they know to bring it to someone's attention, that just gets you to your interactive process faster, and that's what you want.
the other value of training supervisors and managers about these points you're making, Courtney, is it is sometimes a very tough and uncomfortable situation. And I guess my experience is those supervisors, as you point out, are so critical to pulling it off in a productive way. Anytime you can train them and kind of sensitize them and also demystify the process, you're going to have them in a better place if and when they're involved in the accommodation process.
I mean, demystifying the process, that's a really good point, because you're familiar with this. You will have done multiple of these discussions. This is an issue that you deal with, but you're probably dealing with someone who has never been through this before. I mean, they're just now having their first health issues since they've been with you, so they're not familiar with the process. Feel free to educate them a little bit at the beginning of your discussion. Thought, you know what, we need to get some information from you. We need to toss around some ideas with you so that we can find a way to get you back to work. Don't avoid the conversation. The more proactive you are, the more natural it's going to feel. If you wait to the last minute and it becomes a stinky fish issue, it's just going to make for an awkward conversation. Do it as soon as possible, as soon as you hear, as soon as the obligation is triggered. Go ahead and do this. My clients tell me, once you do it 2 or 3 times, you realize it's not uncomfortable. It's helpful for everybody in the room. So don't be afraid of it. Don't be timid, because then it comes across as, you're kind of doing something or overstepping your bounds in some way. Feel comfortable, feel confident asking for the information and talking about the accommodation. Charlie, you got any more last words of wisdom?
The last words, I don't know how much wisdom is involved. Again, just assume, to echo what we've been saying throughout, assume it's always on you. You are always going to have to be the adult in the room. You are always going to have to be the person taking the initiative. You as the employer or the HR professional are always going to have to be that proactive individual when it comes to investigating disability and accommodation circumstances. It's not going to be fun. It's going to be sometimes uncomfortable. But at the end of the day, that's in your job description.
I want to again thank Courtney Brew and Charlie Plumb for presenting today's webinar. And on behalf of the law firm of McAfee Taft, thank you for joining us for another Employer Link webinar. See you next time, and have a great afternoon.